In this installment, Jamie Paquin is being interviewed by me, Dina Pete, on the topic of force majeure. Hi, Jamie. Recently, many tenants are claiming that they're facing delays outside of their control. They all scream force majeure and declare that they're not obligated to perform as a result. I know these are tough times, but does the law of force majeure allow for this?
Actually, there's no such thing as a law of force majeure that automatically excuses parties from performing their obligations when an unforeseeable event occurs. Force majeure is just a legal term that refers to unforeseeable circumstances, much like the COVID pandemic, which interfere with a contracting party's ability to perform a contractual obligation. Many leases will include force majeure clauses. These clauses are agreements between the contracting parties on how to handle the situation when an unforeseeable event arises and a contractual obligation cannot be performed as a result. Usually, a force majeure clause will state that performance of the obligation is postponed until it can be performed. So, if your tenant is claiming force majeure applies, the first step is to check the lease to see if there is a force majeure clause. Without a force majeure clause, neither party can claim it applies.
Got it. I do know that most leases have a force majeure clause, but how do I know what is and is not a force majeure event?
The important thing is to read the clause carefully, as the specific wording of the clause will tell you if there is in fact a force majeure event. Force majeure clauses usually include events such as wars, natural disasters, acts of God, labor shortages and strikes, among others. There is often also a catch-all phrase that captures anything else beyond the reasonable control of the party that has been delayed. More important is how a force majeure clause will be applied. Does the force majeure clause relieve the parties of their obligations entirely, or does it just delay them for a period of time? Most force majeure clauses in leases only allow for a postponement of non-financial obligations for a time equivalent to the period of delay in question. The payment of rent is almost never excused in a force majeure clause. So, if you have a tenant claiming it doesn't have to pay rent because of a force majeure event, the landlord can almost always rely on the force majeure clause to insist on the payment of rent.
That's good. What about important time periods in a lease? Can the commencement of a conditional period or a fixturing period be delayed under a force majeure clause?
Again, it depends on the wording of the lease. Usually force majeure clauses refer to contractual obligations more generally, and important periods in a lease like the commencement date and fixturing period aren't expressly referred to in a force majeure clause. If the parties want the force majeure clause to apply to those important time periods, they should expressly state that the force majeure clause applies.
So, what happens when there truly is a force majeure event? Can a tenant just say, wait it out?
No. If there is a force majeure event delaying a tenant or landlord's ability to perform its obligations, it has to notify the other party. And depending on the notice requirements in a force majeure clause, this notification may need to happen immediately. Also, a party looking to rely on a force majeure clause must show that the event completely prevents performance. It's not enough for a force majeure event to make performance difficult or inconvenient. A force majeure clause will rarely excuse performance just because it is difficult or commercially unreasonable to perform the obligation. The party will also have to show that it took steps to mitigate the impact of the force majeure event and to minimize the delay or losses sustained as a result. It cannot just sit on its hands.
That's great. I'll check my leases to see how they deal with force majeure. Anything else to watch out for?
Sure. It's important to remember that the force majeure clause is only as strong as the clause is clear. If a force majeure clause doesn't clearly state or define what is a force majeure event, it'll be hard for a tenant to rely on it to claim they are excused or delayed in the performance of their obligation.
Thanks, Jamie. Well, I'm off to review my leases. That was Jamie Paquin in conversation with me, Dina Pete, on the topic of force majeure. If you would like to learn more, contact Jamie on our website, dv-law.com.
This audio recording was a general discussion and should not be relied upon as legal advice.